Good afternoon, everyone. I hope everybody's doing well, enjoying this rainy day. Today is Thursday, November 12th, and it's good to be back again. We've taken some time off with our Facebook Live chat sessions, but today we're back, and we've chosen a topic that seems to be coming up on a regular basis, and hopefully you might benefit from it. What I really want to talk about today is trying to leave your assets to your children or any younger generation for that matter. It could be your nieces and nephews in such a way that protects those assets from creditors and other issues that may arise for the younger generations. So often people come in here and they draft, basic wills or basic trust, and they leave their assets to their kids, and they leave those assets outright, or, they don't put a lot of thought into how the assets should be left to the children. And, really you should have a discussion with your attorney as to the different options that may exist, so that way you can protect those assets. Some of the clients that I try to reach out to on a regular basis are the clients that have young children. It's not sufficient, or should I say it's insufficient, to just throw together estate planning documents without contemplating possibly a trust for your children. Younger families, and I often joke about this, but I usually say to people that if you've got young children, your estate plan it's probably more important for you to draft your estate plan than it is for, let's say, a middle-aged family, or even in some cases an elderly family. If God forbid something happens to you at a young age, and you have minor children, we want to make sure that there are proper mechanisms in place, so that way the assets are not subjected to court oversight, so that way those assets may not be dissipated, so that way the right people are controlling those assets. And it amazes me how few, or how infrequent the younger generations really put a lot of stock into this. I usually, sometimes I'll get a little sarcastic, and I'll say to people, if you had to put down a couple $1,000s to join your son on a travel baseball team, let's say, you would do it. But if I ask you to spend a couple $1,000s to sit down and put together an estate plan that makes sure that your son is taken care of if you pass, you'll think about it, you'll hem and haw about it, you'll push it off to the next day, to the next month, to the next year. It's something that you have to do, but you never get around to doing. Why is it that nobody ever gets around to doing their estate planning? I don't know. Maybe they're afraid of me. But a lot of people have the same story. So let's talk about some of the options and some of the issues and some of the things that we are trying to protect against. So what are we concerned about? We're concerned, perhaps you have a spendthrift child. What does that mean? That means that if you leave $10 to your child, he or she's going to spend $15. They're spendthrifts. They spend money like water. They're not frugal when it comes to money management. And you're concerned about that, right? You don't want to leave your assets to a child like that only for those assets to be dissipated, and before long, and I've seen this, the child doesn't have really much in the way of an inheritance. I mean, I've seen families, couples leave assets to their children, which by all standards were really good inheritances, if you would. And in not too long of a period of time, the child has dissipated those assets, spent them frivolously, and has been left with really nothing. And that's not what the goal is. That's not what we're trying to do. So you might have a child that is spendthrift. You might have a child that has drug abuse problems, alcohol dependency, something along those lines. And for those reasons, you want to make sure that somebody can manage the assets of that child for the same reason. You don't want those assets being spent on those vices. One of the things that people are concerned about today is creditor protection. Especially in today's day and age, we live in such a litigious society. You know, what happens if you leave assets to a child and that child has judgments, maybe there was a car accident, maybe they're in debt up to their eyeballs because of their own devices, maybe they've got a business that they're in debt with and the business, you know, could be failing. You don't want to die and leave your assets to a child that is exposed to creditors, because those assets might be used to satisfy those creditors, and that would be a shame. Who, in today's day and age, who would be one of the most, or who would be one of the greatest creditors out there? And a lot of people don't realize this. A lot of people say things like the IRS, but divorcee spouses are some of our biggest creditors today, right? What happens if you die, leave your assets to a child, and that child gets divorced? Well, if the inheritance was commingled, then those assets could be considered marital assets, and they might be subjected to an equitable distribution award. So you can lose your assets to your son-in-law, to your daughter-in-law, even if today your child is not married. If they become married and they commingle those assets. I'm not a matrimonial attorney. I work with some very clever matrimonial attorneys. If anybody's watched my previous Facebook sessions, you'll see Marty Johnson was somebody that I did a session with, who's a good colleague of mine, a good friend. So I don't mean to step on his toes or say anything that is incorrect, but I'm fairly certain that in New York State, inheritances are considered separate property. So when you have separate property, they should not be subjected to an equitable divorce, equitable distribution award in the event of a divorce. But what happens is that while the inheritance might be considered separate property, the children often commingle those assets with the marital assets. So these are the major things that we want to think about. And so the next thing is, well, Sal, how do we deal with that? Well, we usually draft trust. We generally want to work with trust in your estate plan, whether you're drafting wills or revocable trust as your predominant estate planning vehicle. And quite frankly, we usually use revocable trust when we're drafting further trust for the kids. So I'm using the word trust very loosely, and I don't mean to confuse you, but be careful when somebody uses the word trust. There's so many different types of trust out there, and you want to make sure that you understand what type of trust the attorney is speaking about. In this case, most people have a will. Some people have a revocable trust, which we've talked about before. And the purpose of the revocable trust is to avoid probate. So those are usually your operative estate planning vehicles. Then within those documents, if it's a will or a revocable trust, inside of those documents we'll draft further trust for the kids. So it says, when I die, give my assets to my kids, or give my assets to the trustee of a particular trust for the benefit of my kids, and they're considered continuing trust or further trust. So let's talk about two different types of trust for the kids now, right? These are the trusts that are within your documents. In one instance, you can just be very simple and draft a trust that might terminate at a certain age. So, let's say you have children that you're just not sure if they're on on top of things. Maybe they're in college and you just want to wait to see. You think that once they get out of college they'll be okay, and you don't like the idea of a trust that keeps going on for until the child reaches 30 years of age. So this is like a very basic type of trust. It's designed to keep the assets away from your child until a certain age. Sometimes people draft milestones in these trusts. So they might say, okay, I just want to hold this money. I want to use this money as an incentive, so that way my child reaches certain milestones. So for instance, you might say, okay, when you graduate from college, you're going to get 1/3 of the trust, or when you get your first job. I mean, and you got to be careful with this. And I sort of deter people from getting too in the weeds with this stuff, because the drafting could be very ambiguous, if you would. You can't draft for every instance, but some people might even say when you get married, you know. So you set milestones. There might be certain milestones in your life, and every family is different, where the child gets certain distributions from the trust. The trust can also be drafted in such a way where at any time during the pendency of the trust, the trustee can distribute money for things like the child's health, education, daily lifestyle, living expenses, you know, ordinary and customary living expenses. But during the pendency of this trust, the assets are protected. The child doesn't have the ability to go in there and take the assets. So we've got some limited control and protection from creditors. We would definitely use a trust like this at a minimum if you've got minor children. You know, some people might come to me and say, Sal, I don't want to get complicated. I don't want to draft, you know, lifetime trust for my children, but I want to make sure that, you know, while they're minors, that they don't have access to this money, which, by the way, they won't have access to the money anyway, but we don't want the courts to be involved with the assets. So we'll draft, you know, something like this. There's a little bit of a hybrid approach here too. We could draft a trust like this that says, okay, let's terminate this trust at 30 years of age, but you know, I want to give the trustee the ability to hold back these assets. What if I think everything's okay, I think my kids are going to be fine, but what if something goes wrong? What if, you know, my son, you know, develops a bad habit, or my daughter develops a bad habit? We can draft things called holdback provisions, where the trust might terminate at 30 years of age with a holdback provision that says, but if the trustee determines that the assets should not be distributed for various reasons, such as drug and alcohol dependency, spendthrift issues, creditor issues, all these things that we talked about before, that trustee can then hold back the assets and continue to manage those assets in trust for the benefit of the child until the trustee determines that those assets should be distributed. So it's very, you know, interesting to possibly think about that and use that type of holdback provision. So that's a basic scenario. That's, you know, something that almost everybody should be thinking about. A more complicated approach is a lifetime trust, which is becoming more and more popular these days, and largely because of divorce, quite frankly. A lifetime trust pretty much looks like this. I die, and the assets go in trust for the benefit of my children, or my child. Separate trust. Let's say I have 3 children. Each child will have their own standalone trust. And so what we'll say over here is that at a certain age, and we might use the age of 25, at 25, the child who's the beneficiary of the trust becomes the trustee of the trust. So you've got something called a beneficiary trustee. I'm going in reverse. Prior to that, there's a regular trustee, or should I say an independent trustee. So you die tomorrow, your daughter is 15. There's a trustee of that trust, your brother, your sister. They're considered an independent trustee. They are in charge of managing the assets of the trust, investing the assets, distributing those assets to or for the benefit of your daughter in case she needs anything. But when your daughter turns 25, she becomes the beneficiary trustee, meaning there's 2 trustees. You've got that independent trustee who can pretty much do anything, and then your daughter, who's what we call a beneficiary trustee. She becomes a trustee for a limited purpose. She can go into the trust. In other words, there's a bank account that represents the trust assets. She can go into that bank account and take money out for her health, education, maintenance, and support. Those 4 items. Without asking for permission, without asking the independent trustee. Health, education, maintenance, and support. So it's a pretty broad standard, if you would, right? Health, education, maintenance, support. Maintenance and support, it's really what your ordinary and customary lifestyle is. Maintenance and support for me might not be the same maintenance and support for you, right? Somebody might be accustomed to, the life of luxury, if you would, and another person might have, lesser means, if you would. So, if you read the case law on maintenance and support, you'll see that it could vary. But generally speaking, it's a pretty broad standard. And so when your child turns 25, they have that ability to go into the trust. That limitation is extremely important. That limitation is the reason why, coupled with the independent trustee, is the reason why creditors can't touch the assets of that trust. Right? So we'll come back to that in a moment. The trust goes on to further provide that when your daughter reaches another age, and let's just say it's 40, the first age was 25, now we're talking about 40. She's got the power to remove and replace the independent trustee. And so we're creating a certain degree of control over here. As a matter of fact, if you do any research on this and you type in the words beneficiary controlled trust, you'll see that this comes up. We're not trying to necessarily keep the assets away from your child. We're just trying to keep the assets away from the creditors of your child. So by having your child in there with a HEMS standard, H-E-M-S, health, education, maintenance, and support, and giving her this power to remove and replace the trustee at a certain age, that way she gets along with the independent trustee, because the role of the independent trustee is to be able to go into the trust for items that go above and beyond the HEMS standard. So I was talking to a client today, and I used this example. I said, let's say your daughter wants to buy a boat. That probably doesn't fall into the HEMS standard, or maybe it does for some people, but for generally speaking, I would imagine that it does not fall within the HEMS standard. But the independent, so your daughter cannot just go into the trust and buy a boat. But the independent trustee can buy the boat, because the independent trustee can use assets of the trust in complete discretion, right? So you want to create a situation where your daughter gets along with that trustee, not because she wants to be able to buy a boat, but you want everybody to get along, right? So we give her this power to remove and replace the trustees. You may choose, let's say, your brother or your sister, and as she gets older, your daughter, she may not get along with your brother or sister. So we want to have that flexibility so that way she can have the trustee that she gets along with. But if you set it up this way, it goes on for your daughter's lifetime, right? When she dies, it continues for your grandchildren, if there are any. If you have no grandchildren, then there's other ways that we draft these documents. And if you set it up the way I just described, the assets of that trust, generally speaking, are free or creditor protected. They're free and clear. So if your daughter gets divorced, if she gets married and then gets divorced, the assets of that trust are not part of any kind of equitable distribution award. And this is becoming very popular today because, as I understand it, the divorce rate is exceeding 50%. I think it's far exceeding 50%. I think it's almost near 60%. So if your children get married today, there's like a 40% chance that they're going to stay married, which is crazy. It's very sad. And you may say to me, Sal, hey, I'm not willing to take that 40% chance. Let's set up my estate plan in such a way so that way if this happens, I know that the assets are protected. So this is becoming very popular today. It's a little bit more complicated than an ordinary drafting exercise, right? And that's really not for today's discussion. That's for if we get together, we could talk about how to draft these trusts and the way we do it, but it's something that should not be dismissed. You've got creditors, you've got divorcee spouses, you've got lawsuits, you've got all different kinds of things today that require your attention. And drafting a lifetime trust creates a great deal of flexibility for the management and control of the assets. It gives your child a certain degree of control. And I think if any of these instances prove to become fruitful, you're going to be, your family will be very happy that you drafted this way. Now that's a little bit different than a trust where your daughter or your son does not have, they don't become the trustee. When would we want to use a trust like that? A lifetime trust where your son or your daughter, they don't have any access to the money in this trust except if the trustee says so. That's when and generally speaking, you might have an adult child, and you know that your child has some issues, right? Whether it's drug habits or alcohol dependency or just no matter what, is never going to be able to manage a dollar. You might say, you know what, I don't think anything's going to change over here. I don't even want my child to be what we call a beneficiary trustee because they can go in for HEMS and they have access to the assets of the trust. So then we've got to talk about what we call a purely discretionary, irrevocable trust. You die, the assets go into a trust, you choose somebody to be the trustee, whether, like I said before, it's a family member, or it could be an attorney, or it could be an accountant, it could be a bank, a financial institution, and that trust is there, it's available if the trustee says so. So they've got to have a close relationship with your child, so that way when your child comes knocking on the door and says, I need $100,000, we can assess why and under what circumstances we should distribute that money. And if we don't think that, I'm assuming, let's say we're the trustee, if we don't think that it's a valid distribution of assets, the kid is not getting those assets. So we've got complete control in that instance, where we're not going to let this money be wasted on bad habits or spendthrift, practices. We don't see a lot of those, but there's a time and place for everything. And if you have a fact pattern, if you have family dynamics that give rise to this, then you want to get into our office and talk about that. So you can see there's 3 different, types of trusts that I just spoke about, and then each one of those trusts has other, items of consideration, like tax returns, which we're not going to talk about today, but the management of the assets, the investment of the money, right? So, you've got to think through all the issues that surround these trusts. But those are 3 different ways that we can try to protect your assets. And each one has its place, and, some are more popular than others, but it really depends on your fact pattern. So we brought this topic to you today because it's coming up often, especially with younger families, especially, with, the divorce rate exceeding 50%. And I want you to think about these things. I want you to come into me and talk about it because you may fit the bill for somebody that should be considering these types of trusts. It doesn't have to be just for a minor child. It can be for any type of child. As a matter of fact, some people might draft these, like I said before, you might be queasy about a lifetime trust, so we might just do a regular trust that terminates at a certain age, but then people come back and they say, what, Sal, the kids are over 18 now, and we've been thinking about it, and we really want to set up that lifetime trust, we talked about years ago, so let's do it. And I'm happy to help. So that's all for today. I hope everybody is continuing to stay safe and stay healthy. If you have any questions, please feel free to email me. My email address is smd@mfd-law.com. It's really nice to be able to create these sessions when people ask to speak about certain topics. So if you have something that you would like for me to speak about, please let me know, because it's just so much easier when I can respond to your needs. My website is Plan Today for Tomorrow, all spelled out, one big word, Plan Today for Tomorrow. And there's a lot of useful information on my website. We've been doing these Facebook live chats all summer since the pandemic started, and there's quite a bit out there on my website now. And if you want to call us, you can reach us at 914-925-1010. That's the Rye office. And the Yorktown Heights office is 914-245-2440. And with that being said, I look forward to seeing you guys in the future. Take care.